Welcome back. Today, we just want to talk about the history, just a brief about the history of our laws in Zimbabwe as far as they apply to labor law. To kickstart our discussion, I'll indicate three particular years: 1985, 2015, 2023. 1985 is significant to the extent that that's when the Labor Act, as we know it today, was introduced. At least 6 amendments have been effected on the Labor Act. And in our discussions, we're going to be talking about the fundamental changes that have consistently happened on our labor law. For this purpose, it is important to really note that 1985 is significant in our history. It is the year we got our first Labor Act, which was called the Labor Relations Act, and we've managed to sustain it up to today, but albeit through several amendments. Year 2015 is significant in our history in the sense that that's the year we had or witnessed the termination of thousands of contracts on notice. I know of a lot of people who faced the emotional trauma of having to lose a job just like that. 2023. This is the year we received the latest amendment to the Labor Act. So deliberately, I've mentioned these three important phases in our history. Those phases have taught us that labor law is not static. Labor law has this tendency of changing all the time. In my research, I've noticed that the same changes that you tend to face when you're in Zimbabwe are the same changes that you also tend to face when you are in other countries. So, by and large, labor law as a subject has this tendency of changing. So it compels us as individuals, it compels us as employers, employees, trade unionists to be abreast with the developments that are happening in the law. So in this channel, these are the fundamental changes that we are going to be talking about. So what has become also clear is the fact that despite the several amendments that have been effected on our labor law, there is a tendency of having these gray areas that require constant and consistent explanation. We are going to talk about retrenchment provisions, the problems that have emanated from Act 11 of 2023. But besides the historical perspective, there's also a challenge that regards the technological advancements of recent years. Our people, both employers and employees, have had access to information. It could be through AI, it could be from the internet. And 90% of the time, the information is there, but not correct. The purpose of this talk show is to bridge that gap, where we want people to have access to the most contemporary, to the most recent and accurate labor law information. So in our next show, we want to talk about why labor law is important, why there was a need to even come up with labor law in the first place. I hope you become part of our family. Thank you.